Good afternoon and welcome to CUHK Law and the latest in our Greater China Legal History seminars. My name is Stephen Gallagher. It's my pleasure to welcome you on behalf of the Dean, Professor Lutz Christian Wolf, and the whole of the Faculty of Law at CUHK. Today, we've got one of our colleagues who's going to be addressing the seminar and sharing her research into a very interesting legal history topic with us. We're now halfway through the seminar series. This is number 4 out of the 6 that we've got this year. I'll give details of the next one at the end of the seminar as well. But now it's my pleasure to introduce to you my colleague, Professor Miao. Michelle teaches in the areas of criminal law and Chinese legal system. And among Michelle's research interests are the intersections between the domains of criminology, human rights, socio-legal studies, and international law. Michelle has studied post-reform capital sentencing process in mainland China and also examined the role of long-term incarceration and the suspended death penalty regime in contemporary China. But she's also worked on issues to do with long-term incarceration and the death penalty in the United States as well. So she's got a very interesting, I think, sort of comparative edge to her research as well. She's also published, of course, a number of book chapters, many peer-reviewed journal articles in leading international journals as well. But today we're very lucky. Michelle is going to share her insight into the history of capital punishment in China. Please remember, we are going to try and save some time at the end for questions. So I'm sure you will have lots of questions for Michelle on this interesting topic. If you can use the chat function to chat them into me or into our team, then I can ask the questions of Michelle at the end. But anyway, now it gives me great pleasure to hand over to my colleague, Professor Miao. Over to you, Michelle.
Good afternoon. Good afternoon. Thank you so much, Steve, for your very generous introduction. I would like to thank the Dean as well as Professor Gallagher for your kind invitation to me to this Great China Legal History seminar. And it's really a wonderful pleasure to see so many of you here, dear colleagues, friends, and students. So the topic I'm going to explore in the next 1 hour and 15 minutes is about capital punishment in imperial China. So please allow me to share the screen. I hope you can still see my current screen, and if I could, I'll put that on presentation mode. Thank you so much, Steve, for your confirmation. So today, my topic is going to cover a few different sub-areas of capital punishment. They include the origins of capital punishment. Then I'm going to move to discuss the laws and lawmaking on capital punishment with some discussion on rituals and also execution methods. Then I move to discuss some of the patterns in the use of capital punishment in historical China, and then I will arrive at the conclusion. So without further ado, now I'm going to move to the first topic. You probably have noticed the subtitle of my talk is between two different trends or two different characteristics of capital punishment in imperial China. One is brutal, the other is benevolent. So how do we describe capital punishment in imperial China? Should we say it is pretty much brutal, or there are elements of benevolence as well? So here I introduce 2 different paragraphs to you, one from academic writing. Some of you must be very familiar with this. The other from a local newspaper, centuries in the back. So the first one is from Blackstone, Commentary on the Law of England, such a well-known book. So he says there, in China, murderers are cut to pieces and robbers not. Hence, in that country, they never murder on the highway, though they often rob. A second piece from the local newspaper, London Observer. The statement goes, disemboweled corpses were left for days in the streets, no one being allowed to remove them until they were torn to pieces and eaten by dogs. Babies were killed before their mothers' eyes, and the mothers then executed. really, really horrible description of capital punishment. I'm so sorry for opening the talk in such a horrible way, but we're going to talk about some of the evidence, some of the historical archives, and then you can make your own decision on whether you think you agree with them towards the end of the lecture. Okay, so I'll probably just now move to the part of the origins of capital punishment. So there are different theories why in primitive societies, the capital punishment was invented. So there was one of these theories says there's some close interconnection between warfare and capital punishment. So in the sense that armored soldiers are transformed into executioners. So the tools, the weapons were transformed into the tools used for execution. To the extent I draw your attention to this statement in Guoyu, basically it captures the essence that there are 5 types of criminal punishment in primitive China. All of them were used in public. For the most severe type of punishment, you deploy the armored soldiers. The next sub-level for the most grave kind of punishment, you can use axes. For the intermediate level of punishment, knives, chains, drills, and ropes are used. For the mildest form of punishment, then you can use sticks and whips. So the purpose of all this punishment, including capital punishment, is to deter the people. So I think from the very beginning of the primitive society in the Chinese penal culture, you could see an element between the use of capital punishment and the social governance. Then the statement goes again for an emphasis on the publicity of capital punishment. It says again, all these punishments were administered in public in the sense that if a punishment is secret, then this is not considered a proper punishment. I particularly want to draw your attention to this because we can see the change later on. After dynasties of practice, particularly considered today, has this still be the case, the publicity of punishment? Now, the other series explaining the origins, the roots of capital punishment, pays attention to the connection between blood revenge on the one hand and the rise of capital punishment on the other hand. This statement in the historical archive basically describes that blood revenge in ancient China was not only acceptable, but also was a kind of ethical obligation. So the statement goes, if the son do not seek revenge for the father who has been killed, then this is an instance where the son is no longer considered as the son. Of course, biologically speaking, the son was still the son, but I guess this statement indicates that because the son failed his ethical obligation, he is no longer an ethical son of the father. The next statement goes to some of the limitations and procedures of blood revenge. It says, if one's father is killed without any justification, then the son can properly seek revenge. But if the father was killed with justification, because the father has done something wrong or there are some prior disputes, then the son still take revenge on the killing of the father. This is not okay. This is seen as encouraging endless interpersonal violence. It also sets the boundaries in terms of what can do when taking revenge. It says if the son seek revenge, they cannot target any other person, only the person who has wronged their father, right? So they cannot revenge upon the child of the target, the person who is subject to revenge, and they cannot extend to other family members. So when friends, they would like to help the other friends in terms of revenge, the friends cannot step in the position of the revenger and perform the duty instead. The friend can only assist there. So that is the proper way of seeking revenge. There is one very interesting historical case here in the Han Dynasty. Now we move from the ancient primitive societies to the Han Dynasty. So this is Lady Zhao. Lady Zhao was very unfortunate because his father was murdered, but the murderer was very delighted and gloated, to the other villagers, saying, "Well, I'm not going to be in any danger at all because all the sons of this person I just murdered have already died because of illness. There's only one daughter left." From that statement, we can assume in ancient China, it was never a lady's role to revenge on behalf of the father's death. But our Lady Zhao is not a regular lady. So she said, "Oh, my brothers already died, but I consider this is something which is not wrong. So I'm going to take revenge upon the killing of my father." And she succeeded doing so. Afterwards, what is more interesting is she turned herself into the local magistrate. So the magistrate, upon hearing the story, was sympathetic with Lady Zhao. So the magistrate said, "I just cannot bring myself to accuse you and punish you. How about this? I will resign from my position. Right? You can flee from this criminal scene and I pretend this did not happen." Lady Zhao said, "No, it's not okay. I can tell two things apart very clearly. First, as a daughter, because my brothers already died, so I take it is my ethical obligation to revenge on behalf of my father. But on the other hand, I understand the state law does not tolerate this kind of behavior." Right? So from the statement, we know in the Han Dynasty already, there is some kind of limitation, at least some ambivalent attitude of the state law in terms of whether and to what extent private revenge is acceptable. She said to the magistrate, "You are the law enforcement. I cannot let you blind your ethical and legal obligation because you are sympathy towards me. So please arrest me." Eventually, the local magistrate reported this case to the higher authorities, who in turn were very sympathetic with Lady Zhao, and they said, "In this particular case, we want to grant leniency to you, so you are not going to be found guilty." Right? So that was the story of Lady Zhao, and it also tells us, interestingly, the legal status and legitimacy of private revenge in ancient China. So moving from Han Dynasty onward, we saw some further changes. From this statement, the idea is for the avenger to seek revenge if they can report to the authorities before executing the other person, then the court could consider this and declare that person not guilty. So this is a prior condition to taking revenge and in terms of justification. So the last case in this area concerns two Zhang brothers in Tang Dynasty. Now it's 6th to 9th centuries AD already. So we move along the scale of time to the Tang Dynasty. These two brothers, their father were killed or executed actually because of some wrongful accusation from colleagues of their father. The sons were on exile and then they returned to capital city of Tang. At that time, it was Luoyang. 4 years later. So at this time, they were older, but not too old. The younger son was only 11 years old. However, they managed to revenge and killed the other person they thought wronged, were responsible for the father's death. Afterwards, they were arrested by the authorities. At this time, the emperor of Tang convened a panel of grand chancellors and discussed this case. The question was, how should we treat these, brothers who are seeking revenge? You could see public opinion, right? So public opinion sided with the brothers. That is why this was one of the most high-profile cases in Tang Dynasty regarding personal revenge. But the emperor was in a different position, in a different perspective. One of these grand chancellors, whose name is Zhang Jiuling, a well-known politician, so he said, "I would want to save the sons." But the other chancellors, as well as the emperor, said, "No, we cannot open the floodgate, because if we accept personal revenge as legal, what we are going to course, the consequence of this will be a lot of people will seek personal revenge, and they will just say we are doing this on ethical obligations, and this will not be conducive to a good social order. It will cause a lot of social disturbance. Afterwards, the Xuanzong emperor ordered the sons to be executed, but you can understand the public were very much sympathetic to the situation. They crowdfunded the funeral as well as the burial of the sons. They also make great effort to preserve the tombs of the sons. So this last story from Tang Dynasty also, tells us the very kind of uncertain and kind of ambiguous status of revenge. So what does this have to do with capital punishment? I think what we can see on the one hand is the gradual decline in terms of private revenge. On the other hand, we saw the rise of capital punishment. So in the other sense, the power to kill shifted from private hands into public authorities. Now the state monopolized the power to kill. That is the form of capital punishment. Right? So that is the connection between these two forms of killing, from civil society to the state, from private parties to the law enforcement. So this is such an interesting story that it has not only historical implication, but also contemporary relevance. So some of you who are keen on Chinese news would probably have heard about this case 3 years ago, 2019. So this gentleman's name was Zhang Kaokao, was arrested, convicted, and executed in 2019 for doing what? Private revenge. So his mother were killed by two brothers from this, like core villagers from the same neighborhood. And afterwards, Kaokao was very much angry and very sad. So here I have a quotation here. I'm not going to read it from the newspaper reporters who interviewed him while he was in prison, while he was arrested by the authorities. Basically what happened was he vowed to revenge after her mother died, and in particularly because one of the brothers was only imprisoned for 7 years for the mother. I guess this story actually shed some light on the fact that when the legitimacy of capital punishment was not afforded, right? Also, when the legitimacy of other type of punishment was cast in doubt, then what the private parties will do in response. It also may, just give us some implication in terms of the very close interlink between capital punishment on the one hand, and well as the public response to it on the other hand. The other side story is after the execution of Zhang Kaokao, his father refused to claim his ashes. The father said, I don't think this execution, now the state execution of Zhang Kaokao for private revenge is proper. So I'm going to petition, in the future. So I think this is not the end of the story. This kind of vicious cycles of interpersonal violence and kind of very much debated legitimacy of state use of capital punishment. So much for the origin of capital punishment. So I would now like to introduce to you some of the legislation on capital punishment in historical China. So for many of you who are legal historians, I am not myself. So you are most familiar with this statute. This bronze statute is now on display of the University of Pennsylvania. The name of the beast in display is Xie, the symbol of justice, who can tell right from wrong. On the bottom of the statute, there's one sentence. Slow and painful has been man's progress from magic to law. I would like to paraphrase the sentence to describe the talk of the remainder of this lecture, which is slow and painful has been human's progress in the use of capital punishment throughout history. Legislation. So in this table, I have gone through all the historical archives, some of the documents and literature to summarize the number of capital offenses throughout the history from primitive society until the last dynasty, which is Qing dynasty. So this table is a much simplified, kind of table on the left-hand side different historical periods. In some of the historical periods, some of the dynasties, such as West Han, because it's relatively long and multiple emperors, they published different criminal statutes. So I have divided them into specific period as well. On the right-hand side, you can see the number of capital offenses throughout. And here there is a graph illustrating the kind of change of trends from Xia dynasty to until the last one, the Qing dynasty. And we might want to focus on the latter part of this graph, from Han to Qing. This is normally what was called as feudal China, that China was under this particular economic political structure. So what can you see the pattern in the use of capital punishment, or the pattern in the number of capital offenses? So I guess you can see first a decline there, and then a gradual climb, right? So in a sense, the number of capital offenses first dropped, then climbed. And there are many different theories we can use to explain why that is the case. I have my personal thoughts, which I will reserve for the Q&A, because I think many of you might have even better theories than I do. Right? So here I would like to just show you from one of the historical archives by jurist Shen Jiaben, perhaps the most renowned jurist in Qing China, and maybe in the entire Chinese imperial legal history. So Shen Jiaben calculated the number of capital offenses from Northern Wei until to Qing. And I am a great fan, I'm a big fan of jurist Shen. He is really, really wonderful legal scholar. I think his mathematical skills may be a little bit off, right? Interesting. So there is some kind of small errors, but in general, he made a very important point. He said from the early times of imperial China to Tang Dynasty, that was the lowest point in our graph. He said the number of capital offenses almost halved during this period of time. Again, how do we explain this great decline in the number of capital offenses? And we will see later on, it's not only the number of capital offenses in law, but also practice as well. Okay. So now I'm going to move to the use of capital punishment. The first distinctive feature of the use of capital punishment in imperial China is the perfect, if not perfect, at least a good alignment between the use of capital punishment on the one hand and some understanding of cosmic order on the other hand. So that is the interesting penal culture, which is really shaping the use of capital punishment, to the extent that it was the very interesting belief that there must be some harmony between human conduct, including the administration of capital punishment, as well as the larger world and also larger cosmic order. So one of these, evidence we can find in the archive is the timing of execution. So execution could only take place during some seasons of the year. They can only take place during spring, during autumn and winter. These are the season of decay and death, but they are not supposed to be carried out during spring and summer, the seasons of life and revival and growth. And also throughout the month, there are certain days are tabooed. For example, the 1st and 15th day of the month, because these are, according to the cosmic order, the full and new moons. And also because the heavy influence of Buddhism on particular Tang China and many other dynasties as well. So Buddhist fasting days are taboo days for execution. They cannot execute prisoners. There are many other restrictions, to the extent there is a very interesting quote from Body and Morris. So they just said, after cursory reading even of all these documents, we believe that in Tang China, the totality of less than 2 months annually are eligible for execution. And maybe perhaps it's even as short as a single month. So the rest of the whole year is not eligible for executing prisoners. So they said this in a joking way. So if one have to undergo capital punishment, Tang China would certainly to have been the world's best place and time if you have to suffer such a fate. They are saying this in a very joking mode, but I think they make a perfect point in terms of the leniency and benevolence in the use of capital punishment. Back then, again, please bear in mind, this was 6 to 9 centuries AD already. There was a kind of a great level of humanity in the use of capital punishment. Right? And one footnote of this is, of course, you are thinking, okay, only 1 month, but then this means a long time of imprisonment. But again, there's another historical fact is emperors, they regularly administer amnesty and pardons, right? So if there's no immediate execution afterwards, this means a lot of hope to have the sentence reduced to a shorter form of punishment. In other words, escaping capital punishment altogether. Okay, so much for the law and the rituals. I think next we can move to one specific procedure in the use of capital punishment. This is the death penalty review. So many of you are more familiar with this because this is very close to the contemporary practice as well. So there were a lot of practice regarding something similar to death penalty review, but the first dynasty which used it in a systematic way was the Sui dynasty. This was the dynasty before Tang dynasty. One of the emperors, Wendy, he introduced death penalty review into the practice in an effort to avoid wrongful executions. And afterwards, he increased the number of reviews from 1 to 3 times. Then it was in Tang that this practice matured. In Tang dynasty, there was an emperor whose name was Taizong. So Taizong emperor, he made a mistake in terms of executing the head of the grand court, in suspicious that the justice was corrupted. So after the execution, however, he was very much regretful. So now, reflecting on his mistakes, he said, well, in the future, we are going to have reviews 3 times before actually we carry out the execution. And then after a while, he considered the practice. He said, normally, even if I gave it 3 times of reconsideration, still decisions can be made in a split of seconds. And maybe I could not give it sufficient time to deliberate. How about this? I'm going to increase the number of death penalty reviews from 3 times to 5 times. To the extent I will review the case 3 times the day before the execution and twice the day on the execution to make sure that at least I have really more than enough time to consider everything in this case. He also said, on the day of execution is not a kind of happy day. So the royal occasion, please do not prepare wine or meat. I'm not going to drink or eat meat on that day. So what is the consequence of this kind of cautiousness in the use of capital punishment? 4th year into his rule, there were only 29 persons who were condemned to death across the whole nation. That was pretty much almost quasi, I guess, very close to de facto abolition of capital punishment in this particular historical period. This is an illustration of Taizong Emperor listening to the report from the jurists of the Grand Court, and also sometimes, although much rarely, he could even interview the condemned prisoner, asking them to present their arguments. So this last case really proves one point, which is the death penalty review system does work. It makes a difference. Okay? So this case regarding, it's one of the quite famous case in Tang Dynasty called the murder taking place in the Banqiao Hotel. This was the case where 3 imperial guards lodged in the hotel in the evening, and the next morning when they woke up, they were arrested by police officers. The police officers found blood on their weapons. So they were, just saying, we are innocent, but the authorities said, well, we have concrete evidence here. So the case was confirmed, they were accused, convicted, and the case reported eventually to Taizong Emperor. So Taizong Emperor read the case multiple times, and he thought about this case. He said, well, I don't understand some of the details here. First, to my knowledge, most of these killings take place between people who know each other. They must have some prior disputes before, either because they have property disputes or there's some other kind of interpersonal conflict. In this case, these people barely knew each other, but that is not the main point. It could be just a random killing, but even it is a random killing. What I'm worried because it doesn't sound like logical, because if the murderers killed the owner of the hotel, why they didn't leave or escape, or at least wash the blood from their weapon, but they were leaving everything intact and waiting for the arrestment to take place in the next morning. It doesn't make much sense, doesn't look like a rational human being. So the emperor said, I'm going to send out some of the legal scholars, some of the jurists to investigate in this case. And the person sent out is jurist Jiang. Jiang arrived in the city to investigate the case with some very intelligent interrogation skills and some kind of, I would say, very smart technologies, which I'm not going to into detail. Eventually, he found out it was the gentleman who had an extramarital relation with the wife of the hotel owner who killed the owner. But he did it in such a clever way. So he used the weapon of the hotel guests and placed them back into the room after finish the killing. So that was the whole story, but it's interesting to prove that these kind of meticulous, some kind of complex procedures to make sure that the killing, the execution will be at more, as much error prone and less error prone as possible is a very interesting and useful procedure. Okay, so now I'm going to just introduce a few different particular persons as well as cases, involved in the death penalty review. The first is a reviewer in the Song Dynasty. So here is the Chinese and here is English. So basically the story goes, this person's name is Ouyang. So we talk about the national level, what about local level? So Ouyang, Mr. Ouyang Guan, Mr. Ouyang was a local judge overseeing two cities, I would say, or two counties. And he was very careful in reviewing these capital cases and criminal cases. The most important thing he thought was to avoid any kind of mistakes. And sometimes he takes the court document back home and study them after work. And he signed one day deeply in the middle of reading the document. His wife, Miss Zheng, asked him why. So the jurist replied saying, this is a death penalty case, and this person is the condemned prisoner. I would like to save his life, but I can't find any way out. So I have tried my best. And if it still fails, then at least either me or the prisoner are regretful. But even sometimes I try my best, still I fail because I have made my best effort. So I know if I don't make this good effort, then certainly the prisoner will die with a grief. Sometimes for people like me, I care, but other people, they don't care. Some people even want these prisoners to die as soon as possible. So this local magistrate died before his son grew up. The mother of the son told the story about the father to the son saying, I'm not sure whether you will grow up to become a successful person career-wise, but I know your father must have a son of good character. So the rest is a whole history. The son grew up to be admitted to Jin and then become the Grand Chancellor of the whole nation. The name is Ouyang Xiu. So you would know this is a Song jurist and a politician, pretty much well known. And he recorded this case in his own biography. And also he told the story to many other jurists across the country to say the importance of being careful in terms of exercising the life or death power in reviewing death penalty cases. So let's move forward from Song Dynasty now to, I guess, to the last historical period is the Qing Dynasty. So two cases included here. First case is about procedure, the other case is about substance. So they both involve ladies, like female prisoners. The first case is pregnant woman. So under Qing law, pregnant women are eligible for a grace period of 100 days after they gave birth to a child. So if they are pregnant, but they were sentenced to the death penalty, there is leniency for them. I guess it's also maybe because of practical reasons, because the point is to punish the mother, but not the baby, to make sure that they can nurse the baby and have in kind of at least 100 days after the birth. In this particular case, the lady was sentenced first to slicing, which is one of the most severe type of punishment in Imperial China for killing the father-in-law. But afterwards, the emperor, upon review of the case, out of sympathy, reduced the punishment from death by slicing to decapitation. Now the authority at the provincial level from Shandong, they were confused. So for this lady, original punishment was death by slicing. Now the punishment is decapitation. So which is the grace period, 100 days or 1 month? They reported this case to the emperor, and the emperor replied saying, for this particular case, because we already reduced the punishment, so the 100-day rule should apply, and that should be effective immediately. I guess it's interesting because I see such a tiny issue are there to attracting the attention of the emperor and cause a lot of discussion between local level and the national level. The next case is relatively a complicated case. I'm not going to go into much detail, but I'm happy to discuss this in the Q&A if needed. Right? This is a case about daughter-in-law killing father-in-law. I will be as simple as possible. Daughter-in-law had a relationship with father-in-law in sexual, I guess not only extramarital, but incestuous. And the father-in-law, upon found the son knew about this. The son didn't do anything, but the father-in-law was unhappy. So he ordered someone to kill his own son to continue to have this relationship with the daughter-in-law. The daughter-in-law didn't know about the killing in the first instance, but then afterwards she found out. Out of indignation, he killed the father-in-law. Now this case come before the attention of the emperor, who convened a panel of commissioners to deliberate on this case. What I found extremely interesting was the emperor and the commissioners at least consulted 5 different cases across the nation. One case from Yili in Xinjiang province, the other from Heilongjiang, 3rd case from Shanxi, 4th case from Shandong, and the 5th case. So they based their decision on one of the Shanxi case out of so many cases, based on similar circumstances. So the Shanxi case itself is very interesting. This case involved a female prisoner whose daughter-in-law again killed the father-in-law by accident. Basically, the father-in-law attempted to rape the woman. The woman grabbed a knife. It happens the father-in-law lowered his pants. So when they were struggled, the knife cut off the organ of the father, who bled to death. Right? So that was the case. In which case the emperor ordered the punishment to be reduced eventually to life exile, to the extent she could return to her hometown actually and sever the relationship with the family of the father, of the husband. In this current case we are talking about, this present case from Guizhou, the emperor said, let's also grant leniency to the daughter-in-law. Of course, you can understand some of discussion. Some of the jurists said this case is different from that case, because in that case, the daughter-in-law was morally impeccable. For this case, she had this incestuous relationship under Confucianism. That is really not good. Right? And so the emperor said, there is something different, but there is some different on the defendant side as well. In this case, the defendant, the father-in-law, is not a good person, or we can say he's a horrible human being, right? Because he wants to continue this kind of relationship, he killed his own son. And the woman have a change of heart, so she, out of indignation, killed the father. So considering all of these circumstances, I would grant leniency. Right? So that was the story. What I found is interesting, not only in terms of the tension between rituals on the one hand and law on the other hand, between morality and punishment, but also how careful on the national level and also local levels, like judicial authorities consider these cases of great tension. Okay, current practice very briefly. So you could see those historical practice have contemporary memories. So many of you know that the Supreme People's Court, the highest judicial authority in China today, apart from hearing some of the civil and other types, administrative, other type of cases in a very small quantity, there is a large group of judges hear capital cases. They review every single case reported from local levels across China. Every single case must be deliberated and reviewed by the SPC judges. Here is what it looks like from the outside of the building. This is a place where death penalty cases are decided on the national level. Okay, so I will, in the remaining of the time, very briefly. Now I have to speed up in terms of talking about the execution method, the last substantial topic. So the history of capital punishment, right? So we saw 5 types of punishment, which are collectively called old 5 punishments in primitive China. So they include branding on the face, amputation of the nose, feet, castration, as well as death penalty. Then the new 5 punishments, including caning with light bamboo stick, caning with heavy bamboo stick, penal servitude, life exile, and capital punishment. What do you see in the comment? Capital punishment, right? So that was the only punishment across thousands of years. And here's a story of what made the change. You can see what is the transition is from old to 5 punishments. The number of corporal punishment declined. Right? And amputation, those kind of punishment disappeared. This was in the Han Dynasty. The emperor was Wu Di. This girl, 80 years old, Qing, pleaded on behalf of her father. Her father was accused of corruption. So Qing said, leaving aside the issue whether my father is truly guilty or not. Of course, he has a really good reputation. But anyway, I think the punishment is too cruel because the punishment for her father at that time was amputation of the feet. So she said, I know the limbs of the human does not grow back after you carry out this kind of criminal punishment. So I voluntarily surrender myself to become a slave of high status officials in exchange for my father's leniency. Please grant leniency on my father. I want to keep his physical integrity. After reviewing this case, Wu Di Emperor said, I'm very sympathetic, let's abolish corporal punishment. But the only one which left was capital punishment. Okay? The other historical period which saw a lot of change in the use of the modality, the use of criminal punishment altogether was late Qing. This was the jurist which we discussed before, the most renowned one, my kind of idol there, jurist Shen Jiaben. Okay? So he was very knowledgeable, I guess. He is the founding father of the contemporary legal history. And under his leadership, they completely reformed the legal system, including criminal justice system. So they read a lot of foreign law, including the first one is German law, the second one Russian law, third Japanese, and then law in France and law in England and the United States. The product, one of them is this Great Qing Penal Code. They abolished the punishment of caning, either light or heavy. They abolished life exile. So the newer 5 punishments are in the fines, like property offense, fines, as well as criminal detention, fixed term imprisonment, life imprisonment, and the death penalty, which is exactly what we use today in mainland China. See, in terms of capital punishment, also jurisdiction changed the type of modality of execution. So previously, the typical types of execution, including strangulation and beheading. So under the leadership of Shen, he proposed in this imperial memorial, he said, let's abolish death by slicing, display of the head of dead person, destruction of the corpse, and even decapitation. So let's make strangulation the only legal form of capital punishment. Okay? Very briefly, the 2 typical types of executions throughout history. One is beheading, the other is strangulation. Pictures showing the methods. If you are interested, this is not a very light-hearted material, so I'm not going into the details. If you are interested, I'm happy to introduce you to the technique of it, how it's done. But looking, below both categories, strangulation and decapitation, each of them either immediate execution or execution after ceases. Immediate execution doesn't mean immediately, it means it's confirmed. Execution after ceases, meaning these are already presumed to be possible for commutation, for reduction of the punishment. So the question for you is, which is more degrading, decapitation or strangulation? So again, we can discuss this. It's interesting in the Chinese law, strangulation, although a much longer form of punishment and maybe more painful, but it is regarded as the lenient and proper form of punishment. Why? This is an interesting question, why that is so. The last one, very, very brutal. So if you have a, you probably don't like to see a lot of this photographs. Please close your eyes and only listen to my narrative. This is not for gentle souls. So death by slicing, one of the most severe type of punishment. It's called either slicing, lynching, or death by 1,000 cuts, very famous. So they are reserved for the most heinous crimes, which are collectively known as the 10 abominations, the most severe type of punishment, such as killing the parents or killing the grandparents or killing more than 3 persons from the same family or slice any person alive. It's very horrible kind of criminal punishment. Lynching. This word is linguistically very peculiar, right? So some of the scholars, they said, well, it contradicts all this kind of trend we have observed throughout the Chinese history, that there has been this punishment is public in display. It is very slow, at least intended to be slow, right? And it's an ultimate method to inflict pain, and also it not only apply to the physical existence of the prisoner, but also the afterlife. The idea is in the Chinese, a kind of civil kind of ethos or the spiritual belief that the spirit of the dead person will need to return and inhabit it in the dead corpse of the person. So if we destroy or we just break down the body of the defendant, so the spirit will be unrecognizable. There is no place to return. There's no way to enter into the next life or rise up to the heaven or come down to the earth. So this kind of punishment is supposed to have this element of kind of spiritual connotation, which is very much different from the in general secular tone of criminal law in imperial China. To that extent, Bode and Morris mentioned lynching represents a barbaric contribution to the Chinese civilization by the northern tribes. So they were not in the beginning already existed in the Chinese society. They were introduced from the Liao dynasty onwards. So I can talk a lot about lynching, but I think I should move ahead to the two scholar, discussion about this. First is Brooke, Burgeon, and Blue. So basically, in one sentence, what they said is people give too much attention to lynching. So the Western imagination or Western understanding of not only capital punishment, but the Chinese legal system centers around image of lynch. As you understand, that was the early 20th century, because a lot of Western travelers come to China, so they take their camera with them and they, deliver these photos back home after they come back from China. Right? So these scholars said because of this image, they don't see the Chinese legal system as a rational and coherent legal tradition. The other statement here is the punishment was not actually, at least not solely intended for inflicting pain, because the coup de grace was executed at the third cut, and also the prisoners was heavily sedated with opium. So whether it's really intended for pain, or at least solely for pain, or it's have some more religious or some afterlife implication. Okay, so these are two of my questions. We can discuss this towards the end. I will use the next 1 minute to just finish the last two slides. So we can observe these historical patterns changing in imperial China from the torturing and damaging of the physical body of the prisoner to the emphasis on the personal liberty and property of the offender. Right? So from punishing the body to punishing the soul, which is in great alignment with Foucault, for example, highlighted in Discipline and Punish in his really renowned book. In the opening chapter, he described the execution of Damien by drawing on the cautery. Okay? And we can see some similarities and differences between Chinese practice and Western. Both reduced the level of pain, both reduced the suffering. There is a increased amount of humanity and civilization difference. I guess until Qing dynasty, the execution never were removed from public gaze. Second is, I think there is more emphasis on revocability in the Chinese practice. So at such an early historical period, review and reconsider the executions, the death penalty decisions were very much, pretty much a central element of judicial activities. Right? And also there's a meticulous art of governance which is associated with capital punishment. I'm going to the last bit of discussion. Okay? So I was intend to play to you this very short video which charts basically the development of capital punishment around the globe in the past 70 years, from 1950s to 2020. Right? So you can see in China, still it's a country use capital punishment until this present day. And that is also some other countries such as United States, Japan, India as well. But many other countries, including Europe, which is a death penalty free, death penalty zero kind of continent now. So what we can learn about this? I want to broaden the discussion from capital punishment really to the entirety of criminal justice. Because sometimes we see capital punishment as something so peculiar, we lose sight of it is part of the whole entire legal system and criminal system, right? So we saw the continuous trend of avoiding degradation and increase humanity. But can capital punishment be an example? Can criminal justice entirely avoid degradation? Professor Duff, for example, said degradation is the main currency of criminal justice. Right? And Durkheim, who famously charged the collective conscience and the civilization of criminal justice, the culture of penal practice, he admitted himself there is a kind of unavoidable tension, contradiction at the heart of criminal justice, which is between degradation of the offenders and protecting the victim. To the extent how civilized is civilized enough, and what kind of degradation should we avoid? There is an evolving standard of decency which has been built into the practice across thousands of years until today. Some of the things, again, I think is good and ripe for future discussion, and which is probably we want to move beyond discussion about different patterns in the penal culture to consider the real function of capital punishment. Maybe we want to not only look at the past for this talk. This is not about past only. This is also about the present and also about the future. Right? It's not merely about death penalty, but it could relate to the whole legal system. And when we have a deeper understanding of the topic, we want to consider the function again of capital punishment, going back to the very early beginning of it. What is the connection between this and that particular, interaction between the civil society and the state authority? I think those points are really helpful for us to illuminate on the different modalities, different laws and practices relating to the death penalty. With that, I would like to bring my discussion on this topic to the conclusion. I'm sorry for running over a little bit. Thank you so much for your patience.
Thank you very much, Michelle. Well, actually, Michelle, we've still got quite a bit of time left, so we've got time for plenty of questions, which is good because we've had quite a few questions coming in. I should just ask you, though, the illustration you had at the very beginning, just personally for me, why did you use that particular illustration? It was the... Oh.
Yeah, let me go back to one of the reasons I was thinking about you when I was designing. I know you would be interested in this. This is a story in the Han Dynasty. This is called The Revenge of Seven Daughters. Right? This was a kind of mural excavated from Anyang in Henan province. This was on display in the Shenzhen Museum. So you could see that not all of these figures in the red color, these were the daughters who were avenged for the death of their father. As we discussed, that was one of the possible origins of capital punishment in primitive and early ancient China.
Well, thank you. That sort of neatly folds into one of the questions that came in, which was about the case of the daughter-in-law who killed the father-in-law. And it sort of links in as well to the other case that you mentioned about the daughter who avenged her father because she had no brothers. Was there any idea that because of the blood revenge killings, that if there were no sons, that anyone else in the family could adopt the revenge? Could a wife avenge her husband or anything like this?
Well, from my perspective, I certainly think there's no limitation on this, right? But even the daughter-in-law, even the daughter who avenged on behalf of the father, you could see that was considered unorthodoxical. So it was not a kind of general regular practice. Normally this, because of the confusion, again, culture, and in the Asian China, you think that normally falls on the male members of the family in terms of this. Again, for the daughter, she does not per se have an ethical obligation. She could choose not to do this. She took it on herself and avenged because she saw that it was her obligation. It depends on each person's interpretation of what should be done and what is the right thing to do.
Thank you.
Sure.
Another question, sorry to interrupt you. Another question that's come in is really about your title. And it says, thank you very much for a very interesting talk. This particular question comes from somebody who said, I'd never thought before that the death penalty could be seen as benevolent. I think with your title, it's sort of this idea of between brutality and benevolence, but never thought of it before as being benevolent. With the brutality of the blood revenge system, you talked about how there was a sort of change away from that to the state taking over with capital punishment. Do we really know, you sort of mentioned changes coming in the codes. Do we really know when that actually occurred? When we really got a move away from the blood revenge being acceptable?
Right. So there were a lot of discussions. So precisely, I think this took place in the after, I think that was the pre-Tang era already, but we saw even in the Tang Dynasty, it seems that even after the state outlawed such a kind of practice, but still there is a kind of misalignment between civil society, between public opinion and the state law as well. You could see one thing for sure is in the Han Dynasty, especially Eastern Han, which is a later dynasty in Imperial China. Still, there was a lot of possibility that the authority accept and condone this kind of practice. There was one particular separate criminal statute in East Han, which said actually, if there is any kind of indignation out of this, the state encouraged this kind of practice. Then eventually this criminal statute was abolished because some of the politicians and the imperial scholars were against this. They were saying, no, you can't do this, this is too much. So there were kind of back and forth of this in the Han Dynasty. In Tang Dynasty, we saw it's already outlawed as a form of private revenge. But because of the culture, you see the culture have inertia. So sometimes in terms of if the magistrate decided the case on a case-by-case basis, they could still exercise some kind of discretion in terms of granting leniency, granting mitigation, in terms of to what extent this could be reduced to a lesser form of punishment. And regarding your point, you never thought of benevolence could be the word to describe capital punishment. Absolutely, that is the normal kind of case applied to me as well. But I think what I want to demonstrate is not the punishment is benevolent, but how people are using punishment was benevolent. And people at that time, it was centuries in the back, they are already developing a lot of rituals and procedure to ensure the correctness in the use of capital punishment. And there were a lot of intellectual tradition in ensuring the cautiousness in using the ultimate punishment. I think that is something which I mean benevolence.
Thank you. That actually comes in again to the next question that I've got here. So because you make that point, and again, I think you expressed very well the idea that even though there was capital punishment, there was this sort of, it was very well regulated almost. There was the review system. There was the idea that you didn't rush the decisions and everything else. And one of our questions has said that they briefly explored the death penalty system in ancient China, and they said they think in the Song Dynasty there was this principle that life was paramount, And do you think that's what came in? It wasn't just the life of the victim, it was also the life of the person accused of the crime and even convicted of the murder, that it still had to be considered in that way. Life was such paramountly important that this had to be considered.
Yeah, absolutely. Yeah, sorry for interrupting. I have to slow down a little bit. I'm still in the mode of fast pacing. So yeah, absolutely. I think that is the case. I mean, even today, right? So I guess it's in the culture, like we Chinese and Asian, we do think life is very much important. And that is not, I guess, is not limited to penal culture, but apply to other areas of law and social life as well. So that is why I agree with you, our observation, which is really, I think, is bright and brilliant, which is because life of the victim is important as well. So that is why there has been capital punishment. It never had been abolished, but it's used with great caution. Right? So to balance these two contradictory considerations, because there are some people who want it to be retained and not to offend their opinion. That's why we are going to use it. But when we use it, we want to make sure it will be not near perfect, although they are never, but at least there are some effort built into this.
Thank you. And again, that sort of feeds into, we've obviously had a couple of questions, people talking about contemporary China and the use of the death penalty there. And one of them has said this, do you think that the way the punishment is administered in China today or reviewed, how does that work between brutality and benevolence?
Right. I guess this is not brutality anymore because we don't see lynch, don't see slicing, don't see decapitation, etc. Still, I think again goes back to Professor Duff's comment. The degradation is internal, like it's the heart of criminal justice system. Okay? So unless we abolish it, there always be this violation. This is a violation of right to life, right? But again, I think we go back to the important discussion we had before about the importance of protecting not only the defendant, but also the victim, right? But also the whole society at large. This is not my personal view. I'm just, talking about in general, the arguments for capital punishment, because the public want to be protected. So capital punishment, again, the empirical foundation of this is debatable, but at least there is the assumption or hypothesis that capital punishment serves very important as a deterrence. So because of this, then whether we should abolish it, right? So in China currently, for the past decade or so, there has been some debate. But according to some of the opinion surveys, I mean, there has been no national systematic opinion survey, but according to some of them, it seems a simple majority of them at least approve this. But again, we want to take those kind of findings with a grain of salt because we don't know how rigorous these opinion surveys are and to what extent they represent the entire of the population. Right? But going back to the contemporary practice, I think that has been, again, compared with what was done in the past, definitely a civilization process. I think sometimes it's useful not to compare the legal system at a similar historical period, but compare between the past and present. You see there's such dramatic difference.
Well, I think you mentioned as well about how seriously the reviews are taken as well. And I know that I do remember you giving us a seminar internally once about your present day research on China and about how so many of the sentences are commuted as well now, and very few of them are actually carried out. There is a capital punishment sentence there. And again, your research on America as well, I suppose there's a contrast there that you can draw. But a question on the contemporary China, how is capital punishment viewed popularly in China? Because the point that's been made here from the question is, in some jurisdictions, and the jurisdiction that's being mentioned is the UK, politicians famously will not put the question of whether we should return in the UK to capital punishment, reintroduce capital punishment to the people, because of course they're very worried that the people would vote and say you should have capital punishment. There's an idea that there probably would be a majority in favor in the UK. What about in China? Do you think there would, what's the popular opinion there?
So I sort of preempted this question when I was answering the previous question, but still a little bit of explanation. But first, I want to thank you, Steve. That was 6 years ago. You still remember my talk. That was before I officially joined the faculty. And also the US one is different because it's not about abolition of the death penalty, but I'm looking at the alternative to the death penalty, life without parole. That is a US project. So going to the question regarding the popular perception, yeah, I think absolutely in Britain and also in Hong Kong. In Hong Kong, before its abolition, there's no public opinion census. There's no one asking the whole society, do you approve or not? It's just abolished out of the leadership of the elites, not the populace. Right? So I think this is a too profound question. I think it's for a politician, not for a legal scholar as I do, whether we ought to have public opinion. But maybe that tells us something about this society, not only China, but as I've mentioned, United States, India, these like large countries, you know, public opinion plays a role, not only in terms of shaping capital punishment policies and practices, but in many other respects of criminal justice legal system. So that is how the legal system operates in the reality in these countries. It's not what we should do, or, you know, these countries are different. Yes, they are different, but you know, these kind of part of the very small part of the criminal justice system, capital punishment, is a kind of a constituent element of the entirety of the interaction between law and politics. So to that extent, it certainly reflects how law is used in the country. I hope that answers your question, not in a direct way, but it goes around it.
I think so. I know, as you say, it's very difficult to really know. Everyone says all popular opinion in the UK would be in favour, but this is often very small newspaper surveys or whatever, and certain newspapers, of course, have little agenda in the UK. And by the way, in the UK, recent referendum have not been that good, really, when you consider the decisions that have come out from the UK in many ways. So probably not a good idea to put it to the people at times, these sorts of questions. The other thing is a question going back to your presentation and the research you presented there, is to do with your graph where you were showing how many offences had been subject to the possibility of a death penalty. And of course, you mentioned that sort of looking at the trend there. And the question that's come in is, you know, why in the Qing dynasty did we get that sudden, it looks like a massive increase in the number of offences that could be punishable by the death penalty?
Yeah, I would really love to know who asked this question, because I want to invite you to a kind of a feedback. I would like to know your interpretation of this, why this is the situation, right? So one possible explanation might be social disturbance, right? So the other thing is I could see some ethical tension in the later dynasties from Yuan to Qing, because they are the ethnic minority groups rules the entire country, and you saw a lot of, especially during the early period of the dynasty, a lot of confrontation between Han people and other ethnic groups. So to that extent, it's not only reflects what is happening within the legal system, but in the broader sense, in terms of the social relations, in terms of the condition of the military defeat, and in terms of diplomatic, sometimes the relations, whether in the Han dynasty, which is at one time it was very high. This was the historical period where the Han ethnic groups had a lot of warfare with the northern tribes, Xiongnu. So the kind of punishment, again, we can see the connection between military operations as well as domestic use of capital punishment to the extent. But that is only one of the interpretation. If any of you in the audience would like to contribute and let me know your opinion, I'm more than happy to really listen to and learn from you.
Okay, well, we might get some comments coming in, but again, back to that, just on me, I'm looking there at that, at the Qing, the number of offences during the Qing dynasty. Do you have any knowledge of a further breakdown? Was that a sudden thing when the Qing emperors came in? Did we suddenly get more of criminal offences being punishable by death, or is that something to do with towards the end of the Qing dynasty, when of course there were lots more problems happening? Because the early Qing emperors were quite powerful, weren't they? In the late 17th century through the 18th century, I think they were quite powerful and probably had quite a lot of control. I didn't know if it varied during the Qing dynasty itself.
Right. So one of my kind of not conventional, unconventional interpretation of this, I think it also has got something to do with the way legislative techniques were used. Right? So if we look at Yuan dynasty, this is not a dynasty which is known for its leniency or its advanced master of culture in China, but still in that dynasty, you saw the number of death sentences was not so large. But Qing dynasty, it is very long, right? Towards the end of it, the society developed to a much higher degree, as well as the legal culture and the way that they compile statutory codes, as well as not only in terms of statute, but sub-statutes as well. So the society may have grown to a kind of, kind of unprecedentedly, kind of a very much mature degree there are a lot of complexity of social activity and interactions were introduced. The society itself changed. Of course, there could be, not always have to be, there could be the possibility to match the criminal offenses to the changing practice in social areas. So that's one of my my interpretation of this. I don't think this have absolutely 100% correlation with the military or the collapse of Qing towards the end. I think it's probably maybe because of the degree of social development. So that's why I don't think the number of capital offenses is the sole criteria. It tells a story, but it's not the sole criteria in terms of measuring the level of civilized, or if you like, the kind of the use, the degree of use of capital punishment. We did consider other types such as review. We saw in Qing, the procedure was pretty much meticulous, very mature. Right? So that is one aspect as well. So I think we want to take this from a kind of organic view with a total perspective to see what happened in one particular historical period.
Thank you. We've got some questions on your actual research methods now. And this is, thank you for a great talk. You quoted very interesting cases. How did you select them? Are these cases representative? And how many ancient capital punishment cases are recorded?
Right. Absolutely not representative. There's no way I can go back to all these cases in the history, and there is no way I could, even by reading the historical archives, that those people who document the case were representative of all the cases happening in the past. This is not the historical period I'm living in today, so absolutely not representative of all the cases. And these cases are some of the cases I read before through my previous research from a historical record, and I read some of the Qing historical like case books and some of the Song and Tang. So from these, I found them because also I adapt them for the presentation. They are interesting. There are a lot of boring cases, which I didn't include in here because these cases demonstrate some kind of social tension and the conflict between morality and law. That is why, but there's no way these are selected for kind of to represent the what happened in reality, just for the presentation.
Great, thank you very much. Yes, I can understand what you're saying there, but the follow-up on this is then, you mentioned that Qing jurists argued that the last case you discussed was different from other cases. Does that mean there was something like a case law system?
Which one this is referring to? The last.
I'm trying to remember what the last one was. Was this the last case? Was that the daughter-in-law case? Because I think you did try and say that it was distinguished, wasn't it? It was argued that this was very different from some of the other cases, because was it the case where one of the daughters-in-law, her morality was impeccable, and one of them, of course, had probably done things that others would consider to be wrong. Right.
Absolutely. So the question, I guess, is why this case is so peculiar, it's so special. Again, I select this case because I found this interesting in terms of the dilemma that women will face in imperial China. On the one hand, they face this ethical obligation to protect their chastity, right? So if they fail so, they are facing punishment. because there is confusionization of the legal system. On the other hand, they also under the ethical obligation not to injure or not to kill their, especially the senior members of the family. This is patricide, right? So that is also eligible for the most severe type of punishment. So what I can see is an interesting contradiction, an interesting conflicting kind of tension between the morality on the one hand and also the other on the other hand. And in terms of the other cases, which I haven't had time to introduce, these are the cases in Yili, in Heilongjiang, and in Shandong province, all daughter-in-laws killing father-in-laws. Right? So normally involving kind of either voluntary or coerced or kind of induced sexual relationship between them. And actually, I don't know why. I went to search long case books before the talk, several weeks in the past, and I searched and searched, didn't find any such daughter-in-law and father-in-law relationship. I was asking, I was talking with my friend saying, why Qing dynasty is so interesting? And the other thing is I also found a lot of these cases, not daughter-in-law and father-in-law, but gentlemen and people who are trying to rape them. So, that is something I've never thought would be documented at large in the kind of Qing case books, but it really indicates the Qing society is pretty much very similar to our society now. So the kind of a diversity in terms of sexual orientation, etc. So I don't know, because I'm not Qing person, but it's definitely interesting to me because of such a rich corpus of of cases. I think that it was a kind of prevalent practice in Qing China. I can't explain, but I paid attention to it. Thank you.
That's probably why these costume dramas are so popular on television, isn't it? When they dramatize some of these things, these strange or colorful stories, at least. But that raises the question of you mentioned about the sort of Confucian teaching and the respect and everything else, and the fact that these relationships would have been forbidden. Would adultery between a father-in-law and a daughter-in-law have been punishable by death as well?
Yeah, absolutely. Incestuous. So this is really bad. It's a violation of the Confucian rituals and the morality. This is not something good. No.
Okay, good. And more on your research methodology. Where do you find materials on capital punishment, and how do you decide that the case is a case to talk about? Is it just because it has these wonderful facts that you can tell us about?
Yeah, absolutely. Again, it's there is some commonality between this question and the question before. So I already explained that when I did research, this is not representative. I found interesting is, people are, at least this community of legal scholars, so talented and so solid on methodology to the extent that it might give me some inspiration. We can do a kind of using contemporary empirical research skills to investigate historical cases. But of course, we understand there are a lot of limitations. For one thing, you are not collecting these cases, when you have the capacity to do so. I read these cases out of this very difficult to read historical language, like the original writings. Although this procedure itself was pretty much challenging. I didn't read all of them. It's beyond my capacity. I went to the library and the whole shelf is about the case books. And I will have to do a third PhD degree to complete this project, right? But I agree. There is a lot of interesting possibility to investigate more deeply and thoroughly into the entirety of the cases which at least available to us. But I don't think you can claim anything similar to the number of cases we can find today through the court system. It's very different.
Yes, absolutely. Well, you did find some very interesting cases for us. So that's and of course fact patterns that are sticking in our minds. As one of our commentators suggests, father-in-laws sound really dangerous. But I don't think I think that's possibly just hopefully in the Qing dynasty. And now I think quite a difficult one for you, but I'll try this. Let's see if you can do this. Can you summarize again in 3 sentences how the practice of capital punishment developed and what the key features of that development were?
Right. Thank you so much for the opportunity. I was quite in a hurry towards the end, and thank you so much for giving me this opportunity to reflect back on the trends of this. So first, I would say there has been a civilization. The first sentence, there has been a civilization process. So there was a reduction of suffering. There is a reduction in the level of pain. For example, slicing was sedated by opium, and also the kind of duration has been reduced as well. The second sentence, I would say there is something quite special to China. First is publicity, which is really emphasized in the use of capital punishment even towards the end of the dynasties, even if after civilized use of capital punishment. Third, I think the most important thing is the connection between capital punishment and the idea about the interaction between the civil society and the authorities. So that is my functionality argument. And so what is the function? What is the function of capital punishment? What function does capital punishment performs? So third sentence. Thank you so much for the opportunity.
Thank you. And now a question again about that chart, which is linked into what was asked before about the figures you were showing and how interesting it was that the number of offences that actually came through. But again, where did you get those numbers? Where did you get those figures? So question number is.
Yeah, so I first went to Shen Jiaben. Of course, he's the person to refer to, right? So I went to his writings, 2 of those books, and I found this particular page, and I read it and translated them into, I don't have translated in English when I'm thinking, but I translate them into English when I making these graphs. And then from his indication, I went through some of the dynasties one by one. So I go to, from each of the dynasties, they have these particular legal writings, legal historical archives. I went to this legal archives and found the page where they have the number. But sometimes some of these dynasties, I don't have the precise number. So I relied on the secondary material, such as the writing of Shen, as well as one of these writings on body and morals. This was a 1967 publication by Harvard University Press. So they introduced the imperial Chinese law, and at the end they studied, I think, hundreds of cases back from the imperial China. So that was, to me, one of the very important source of information as well.
Thank you. And we've got questions about the photographs. You showed us a couple of photographs. They weren't, some were pretty gruesome, but they weren't. I have myself seen many more gruesome photographs of executions ongoing. You also had, for me, I'll bring this bit in, you had those, the pith paintings. So the paintings of the tortures that were inflicted and the executions as well. And many years ago, when I was an antiques dealer, I remember buying and selling these pith drawings. They were very collectible, and there were many of them in Europe, particularly in the UK. Many collectors had in the past got these. My question on those pith drawings is, do you think they were made mainly for a Western market? Was this something that people in Europe and in America were much more interested in, saying, oh, this is what they do in China? And of course, the Chinese artists realized there was a market for these representations.
What a brilliant question, and what a difficult question. It's really difficult to answer that. From what I know, of course, there's no way I could even be any close to your understanding of art and this antiques, and I have absolutely no knowledge about heritage, etc. But I think what you are, if I'm right, what you are actually, I think you are hinting towards is correct. To the extent there has been a gap between Western imagination of capital punishment and legal system in China, as well as how in reality they were used, right? So that is why I actually in the beginning introduced to you. So in the public discourse on this London newspaper, how the news reporters were describing the legal system in China. And this is interesting for 2 reasons. The first is, I guess at this historical period after Industrial Revolution, already in Europe, this kind of cruel punishment already were abolished. Of course, Alabaster and others made the point, so they were not abolished so long ago, but it was already unavailable. So it's kind of relate to their past memories. So that's why a lot of people are interested in this. So they saw it as a public spectacle. They want to see these images. They want to also, in other way, they would like to use as a handle, as a vantage point to critique the legal system in China. To that extent, it's not my opinion, not my own words, but for example, the book by Brooke Bergen and book Blue, which is a really wonderful book, 2008, on Death by 1,000 Cars. I think it was the first 10 pages they mentioned. They're saying it seems these photos actually, when they were introduced into the public discourse, they also introduced some prejudices and bias towards Chinese culture. And to that extent, they would like to restore what really happened in Imperial China. But it's definitely all these arts and paintings and everything tell the story. It is not only about China, it's also about the people who watch them and people who take the pictures and people who circulate and consume them. It's more about that society than about the original society.
I think you're right. I mean, I can only think of the pith paintings, and my experiences, I've seen very few of them in Asia, in collections or for sale, but very much in the UK when I used to buy and sell these things, and relatively recently I bought some, so I've got a few of these somewhere. When I get them over to Hong Kong, I'll let you see them if you like these things. But the photographs, the question that came in, and sort of paraphrasing that now because of what you said, is what the questioner was really saying is, were these photographs really being used, taken to go back to the West because, as you say, even though it only recently these things have been abolished, capital punishment was still taking place, but it wasn't taking place publicly as much, at least say in the UK. They fed a sort of a desire to see images like this or think about this again, and perhaps even, as the questioner was saying, is they fed a particular narrative that perhaps was popular in the West or was being promoted in the West about China as well. Yeah,
absolutely. I can't agree more with that conclusion. Actually, I'm not personally in agreement, but I think it's a brilliant comment. I want to be neutral as much as possible. Yes.
But I think your quotes at the beginning, and again, they were brilliant quotes to put in there, especially that one from 1928, when they're talking about this, when you consider that it's only a little while before that there were public executions. And of course, public executions were hugely popular in most places where they took place. You know, they were festival days almost in many ways. It's quite strange when it is interesting when you put forward the ideas of how few days could be used for execution at times in China, and of course the way that those who were involved in the decisions would refrain from any sort of enjoyment on the days when decisions or executions had to be taken place as well. When you contrast that with some of the celebrations that went on in London when people were being executed and other things as well, it definitely seems much more towards the benevolent and the brutal side in many ways of the past. So publicity was an interesting thing you said as well about the need for publicity. Again, that had always been the argument for capital punishment in the UK, that the executions were public because you had to keep the people in control. You had to show them, what happened and make sure everyone saw the punishments taking place. Anyway, I think we are just about, I'm afraid, at the end of our time. Yes, we're getting other comments coming in. I can't redo the other questions now, but I might try and save those for you later on. So apologies if your questions didn't get read out and asked to Michelle. I'd like to thank Michelle very much for such a great presentation, really interesting presentation, as we can see from all the questions that have come in, so many people interested in this. We may have to ask you to come back, I think, Michelle, to follow on this in the future. So thank you very much for your seminar. We've also got to promote some upcoming events. So I think if you stop sharing, Michelle, I think Connie will be sharing some slides. So we've got the next in our Greater China Legal History seminars, which is taking place on the 10th of February. And of course, that's our old friend, Mr. Malcolm Merry, who will be back with us. Now, Malcolm's given a couple of Greater China Legal History seminars in the past. Of course, he's usually focused on his expertise to do with land law, and in particular, of course, the land law of the new territories. So he's talked to us about the small house policy in the past. But Malcolm, last year, he had a new book that came out, which is about, of course, the aircraft that were, subject to a legal dispute in 1949 at Kai Tak Airport, because, of course, they were meant to be delivered to China. And then, of course, we had the revolution. and there became a real dispute about what should happen about these aircraft, a legal dispute. And of course, there's also a wonderful story which goes with this, which is a story of, well, of courage, I suppose, in some ways, in trying to get these aircraft into China. And Malcolm's got the new book out. He'll be talking about that on the 10th of February. There will be legal issues discussed. But again, as with Michelle's, it's interesting stuff as well, that I'm sure a great story being told by Malcolm on the 10th of February. So please feel free to join us for that. And the details are on the website as well. And the second event, I can't promise this will be as exciting, but well, my colleague Michael Lau is part of this maybe, but I'm doing a seminar with Michael in the property law seminar series, where we'll be talking about a relatively recent Supreme Court decision from the UK to do with proprietary estoppel, guest and guest, and we'll be talking about the approaches to the relief that is available if someone is successful in relying on the doctrine of proprietary estoppel, and whether we look at the expectation as the grounds for relief, or whether we look at the detriment that has been suffered by the person who is asking for assistance by way of proprietary relief. And that's next Wednesday, 5 till 6 p.m. In the property law seminar series. So again, thank you very much to Michelle for a wonderful seminar. Thank you to all of you for joining us. We had many old friends joining us today. It was very nice to see some of the names and get some messages through from old friends and of course colleagues as well. And thank you to all the new people who have joined us today. And we hope to see you all again at our next Greater China Legal History Seminar Series. So thank you very much. Goodbye. We are CUHK Law. Bye-bye.